a crew in town. The head hillbillies are making their rounds. Small town whispers loud and clear. The sheriff shot the judge in his chambers chair.
Sheriff got a secret he won't keep. Judge shot dead in his disbelief. A lot of people have some stories to tell. Dog passed away, get the sound of a shotgun shell.
All the secrets spill on down. Voices loud in this old town. From the courthouse to the ground. Rumors fly and they can't be bound.
Neighbors hide behind their blinds. Whisper tales of troubled minds. Skeletons covering the mountainside. A treacherous reality in the pines.
Winter reveals the hidden lies. Moonlight couldn't match the cries. Shadows caught in sunlit skies. There's no cover, no disguise. All the secrets spill on down. Voices loud in this old town. From the courthouse to the ground. Rumors fly and they can't be
Winter reveals the hidden lie. Moonlight, the mask that cries. Shadows caught in sunlit skies. There's no cover, no disguise.
All the secrets spill on down. Voices loud in this old town. From the courthouse to the ground. Rumors fly and they can't be
Hello, everybody. Welcome to the show. Come on in. My name is Elizabeth, and this is Hillbilly Crime. Welcome in. Sweet Tater's supposed to be here. Make sure we are on. She'll be here in just a minute. I sent her the link this time. I hope everybody is doing well. I'm going to put my possum earrings in. One of our hillbillies sent me some really, really cute possum earrings because we are all about possums. And I found out, there's Sweet Tater. Hey, there she is. Pull your camera down. How you doing there, Mommy?
I'm doing great. Look who I got on my shoulder.
Oh, you've got your baby there. She's hiding her little face behind your shoulder.
Just snuggling.
Oh, she sure is cute.
She's really cute, and she just curls up in the tightest little ball.
Yeah. Well,
And
she's
then
being
And
shy.
then when we sleep, no, it's for warmth. And then when we sleep, as she gets warm, she'll stretch out along my leg.
Oh, well, she sure is cute.
She is.
As we come in, if you don't care, hit that like button for us. It helps us so much more than what people realize. It gets us out to a bigger audience of people. And listen, you live and you learn, trial and error. I made a boo-boo a while back, about 2 or 3 months ago. Before every show, I would go in and manually preset all of my settings. I would turn my monetization on, and I would set the playlist, and I would put in my hashtags and make sure my category was set correctly for my show. And for a whole year, that's how I did it. And I didn't know that there was a presetting that I could turn on that would go ahead and turn on my monetization. Well, I found that presetting, and so I set it, and then I was no longer going in before the show and manually putting all of that stuff in, right? For like the last 2 or 3 months, I had not been doing that because I thought that the preset, was taking care of that. Well, gradually, the show started having some issues, and I just couldn't put my finger on it. I was working all the time trying to figure out what was. I knew something was going on. I just didn't know what it was. Well, last week I found it. Last week I found what was happening, and so I had to go back in, and they where I wasn't going in and putting that preset in there, or going in and manually doing it before each show, it was automatic by default. It had threw us out of the news politics category that we had been in all year and a half. And it then threw us into the entertainment category, a completely different category than what we had been doing for over a year. And it wasn't, the shows were not getting put in the appropriate playlist. They weren't getting put in any playlist, and there were no hashtags set on. So over the last 2 or 3 months, some of the algorithm things have gotten kind of off kilter. So now that I've identified the problem and I've fixed everything, and so from now on, but it's going to take a little while, it's going to take a little while to get that fixed in the algorithm. So, it is what it is. You live and you learn, trial and error. So it's really important if you guys could help us, hit that like button, make sure you're subscribed, share, just do all of the things that we normally do. And eventually, I'm not going anywhere. I show up every single day, regardless if it was just me and my mods sitting here. I'm going to be here. Hillbilly Crime is going to be on every evening. Okay, so if any of you all caught the Screaming Eagle today, they had a nice write-up in there on my lawsuit, on my federal civil lawsuit that I filed. Now, here is the photo, of course, that the Screaming Eagle used. It's the one that everybody got so upset for me posting. Now, this is me down in the corner, you guys, right? You see me down in the green sweatshirt, down in the corner. And then there's ball moms all around me who are also filming their kids. And you see Miss Lila Steins, Mickey Steins, former Sheriff Mickey Steins' daughter, sitting up there behind me. I found that very interesting that the Screaming Eagle decided to use this picture, right?
Well, I thought it was great.
Well, yes, I love it. But why is it okay for them to use this picture, but it's not okay for me to post it on my own Facebook page? Right?
Oh, I didn't know it wasn't.
Right. Well, it is. Like, I posted this picture on my Facebook, and all I said when I posted this picture was, we had a great first ball game. That's it. I didn't mention her. I did not point her out. I did not
Quit that.
give any attention to her whatsoever. All of her own friends did. All of their own people pointed her out. I did not do that.
Well,
But it caused this great big rigmarole. And I think it was kind of a setup, actually. But anyway, so now this picture doesn't have anything to do with my lawsuit. Not really. It does not. This picture is just one that the Screaming Eagle decided to use, to take and use for their article. Now, here is the Mountain Eagle's article. This is what they wrote today. Federal lawsuit involving Jenkins schools and social media content creator continues. Federal civil rights lawsuit filed by Letcher County parent and YouTube content creator Elizabeth Jones against the Jenkins Independent School District and its officials is moving forward in the U.S. District Court. Today, an attorney for the school district filed a motion asking the court to dismiss claims against him personally, arguing that lawyers for public entities cannot be sued under federal civil rights law. Earlier, a federal judge denied Jones's request for an emergency order lifting a district-wide ban that bars her from the school property and school-sponsored events. The judge did not rule on whether the ban itself is constitutional and will consider that issue later. Full details, legal background, and what happens next will appear in the February 11th, 26 edition of the Mountain Eagle. Note. He made sure he put a note in there on the photo. The photo accompanying this report was taken during a public athletic event at Jenkins High School and later became part of a broader dispute referenced in a federal lawsuit involving the Jenkins Independent School District. He's wrong about that. This photo was not referenced in any part of the lawsuit. Not one part of the lawsuit. We're getting ready to go through the lawsuit. So I'm not sure where, if he was just trying to lie and tell everybody that that's why he decided to use that picture, because that picture has absolutely nothing to do. It's not an exhibit in the lawsuit. Nope. No, it ain't. We're going to go through it. I'm going to show you. We're going to prove it to you. The image, which shows Elizabeth Jones at the bottom right, is cited in court filings as part of the background leading to the district's decision. No, it's not. No, it's not. To issue a ban that is now being challenged in court. That is not true.
well,
We're going to show you.
it doesn't make any difference, really, though, does it?
It does to me.
I know.
Because I think he's trying to, he wanted to use that picture, I think. Now, this is just my opinion. I think he wanted to use that picture because it has Mickey Steins' daughter in it. But that picture had absolutely nothing to do. It was not referenced in the ban letter. No, it wasn't. It's not referenced anywhere. That picture is not referenced anywhere unless he has a source that is inside the school district and he has some kind of inside information that he has gotten from one of the school board members. Now, that could be a possibility, and he's let it slip in this note, and he's just not said that this came from a source, but it is not cited in any part of the ban, and it's not cited in any part of the lawsuit. So what he put in there is false, 1,000% false. He could have found that out if he would have read the papers. All he had to do was read the lawsuit. It's nowhere in there. We're getting ready to read it together.
Well, I thought it was a good picture, and I thought it was, sort of informative, because all of this started about them tromping after you after you started your after you started your show, and your first person was Mickey.
Yep. Okay. Well, let me get this up here. We are going to go through the complaint. We're going to read my complaint that has been that we filed, and then we are going to also go through these orders that just okay. I remember what I'm doing. Sometimes I forget where I'm going and what I'm doing here. All right. So this is the memorandum opinion and order. So in one of these, let me get my notes here. Let me pull this up let me read this. Okay, welcome back to Hillbilly Crime, y'all. If you're a long-time listener, welcome home. If you're new here, I'm glad that you found us. My name's Elizabeth. And then we've got Sweet Tater here, as everybody usually already knows. Okay, now we're going to talk plainly tonight without pretending that we are something that we are not. We are Appalachian. That's it. We are observant, and we are not afraid to learn out loud. And so that's what we're going to do with these lawsuits, or with these documents. We're going to learn together, because I'm not a lawyer. I am not an attorney. I was not trained, and I was not educated in the law. I have a master's degree in criminal justice, policy, and leadership, so I do know the process of the court system, but I'm not trained as an attorney. I'm not trained as a lawyer. So that's a big, that's a big difference. Okay. Tonight's episode is different. We're going to try not to be dramatic. I get really upset over this stuff. So I'm going to try to whistle. Let the Holy Ghost grab a hold of me. I'm going to try not to be reactive. I'm just going to try and be very deliberate. So I wrote me some notes here for this. So for the first time, I'm going to sit down and we're going to walk through my federal civil rights case from the very beginning, using the actual court filings on screen in real time. All right. Now, I want to be very clear about something before we go any further. I'm not here to argue my case. Not tonight. That's not what we're doing tonight. I'm not here to convince anyone of anything. And I am not here to speculate about outcomes. Everything we're going to read tonight comes from public court records. In the American legal system, a complaint is not a verdict. Okay? A motion is also not a finding. And an order doesn't always mean what headlines make it sound like. So tonight we're going to slow it down. We're going to read. We're going to explain. And we're going to learn together how a civil case actually works. How many people do you hear? Well, I don't know about you all, but I hear it daily, every day. Somebody has a case. Somebody wants to file a civil lawsuit. Somebody feels like they have a case, and usually they do, right? But there are so many other factors that go into filing a civil lawsuit. You have to have an attorney. You have to find an attorney that will even agree to take the case and put their name on it. okay, their reputation. That's hard, especially in Appalachia, where people are more concerned with their careers, right? Their own career takes precedent over whatever case you think you have. Now, how these civil cases work, I'm learning as I go. I guess the civil lawsuit that we saw with Sabrina Adkins. So Sabrina brought a civil suit against Mickey Steins and the sheriff's department. That was really, I guess, the first time I sat down and went and read through a civil lawsuit with the depositions, and it's just really my first experience paying attention to the process and just all the things that happen within it. And then we see Judge Kevin Mullins's wife. She filed a civil suit against Mickey and his deputies at the sheriff's department for a wrongful death civil lawsuit. So we've been going through those filings in that case. And so now that I filed my own civil lawsuit, completely different, right, on completely different grounds and stuff, but still they're civil lawsuits. They're federal civil lawsuits. So they go through, well, now I don't know about Judge Mullins. I think that's a state filed civil suit. I don't think that's a federal civil case. But so we're going to try and learn through these civil cases. And trust me, there's lots more to come. We've got more cases that I've been working on that also have civil lawsuits filed that we're going to be looking at. So one thing I've learned through this process, and I think it's important for everyone watching, is that civil litigation is procedural. Cases don't move on feelings. They move on filings. So here's the basic roadmap, and this applies, let's see, whether you're suing a school district, a corporation, or a government entity. Okay. So first, the complaint. All right, let me pull it up. How is everybody? I hope everybody's doing good tonight. Everybody's staying warm. Okay. So here is the complaint, my complaint that I filed against the school district. Okay. Now this is just the very front page, and it shows all of the people that we included in this. Now we screwed up, but in the big picture, the big scheme of things, it wasn't too much of a screw up. And I learned a lesson. I'm going to read it to you here in a minute. So you see all of these people. We've got the entire school board named in this. We also have the superintendent, Jenkins, Superintendent Damian Johnson is included in this. And we also included the lawyer that they used for the entire school board, who also is the one who crafted the ban letter. So the lawyer's the one who did it, so we had to include him. Now, he has been dismissed from the lawsuit as of today. That lawyer was, but we knew that that was going to happen. That was procedure. It was something that we knew was going to happen, okay? That's the document. So this right here, this is the document that starts the entire case. It lays out allegations, not conclusions. Then you have the motions that come in behind it. So we had to file this first. It requests asking the court to do something or dismiss something, right? Those are the motions. Motions request asking the court to do something or dismiss. So what we asked the court to do was to a TRO, a temporary restraining order. We asked for a temporary restraining order. Well, whenever we read this decision that the judge wrote, at first when I started reading it, I was like, man, I screwed up because we didn't know to put the date of the 8th grade night. I didn't know what date the 8th grade night was at the time that we filed it. I didn't have those details, so we didn't include them in there. And I should have included them in there. I should have made sure that we found out the date and had that in there. But because we didn't do that, because we didn't put the date in there, then we didn't have in the right requirements. But we're going to read it. All right. But that's where the judge explains the orders, are where the judge explains what they're ruling on. And just as importantly, what they are not ruling on. Okay, so they did not rule on my case today. And most cases are not decided in one moment. These usually take years. They unfold as it goes. So here's the context for this case before we read anything. I am a parent. I am a single parent. Always have been, of 2 teenage boys. My children both attend school in the Jenkins Independent School District and have been there for 5 years. In December of 2025, I received a letter hand-delivered to my home banning me from all school property and all school-sponsored events, including events involving my own children. The complaint alleges that this ban was imposed without any notice. Never got no notice. Without a hearing. Did not have a hearing. Without identifying specific misconduct. It was very general, very general. There was it did not specify any specific conduct or misconduct. Without a time limit, there was no time limit involved. And without a way to appeal or even review it. It was just an all ban. Now, those allegations are what triggered this lawsuit. Okay? Now that we've set the table, we're going to start where every case starts, with the complaint itself. I'm going to I've already put it on the screen, and I'll read key portions out loud. Some parts I'll read verbatim. Some parts I'll summarize. because not everything needs to be read word for word. Okay. Again, allegations are not findings. This is how the process begins. Okay, is with a complaint. So now, this is the verified complaint filed in federal court. And we're going to read the nature of the action and explain the First Amendment and due process claims. Okay. So, defendant, oh, that's Crawford's. All right, nature of the action. So, this is a civil rights action under 42 U.S.C. at 1983 to redress violations of plaintiff Elizabeth Jones's rights under the First and 14th Amendments. Government retaliation for protected speech violates the First Amendment. Number 3, parents possess a protected liberty interest in participating in their children's education and school activities. Now, mind you, I've been doing my photography for the last 10 years, and not one time has there ever been any problem, not one. Nobody has ever tried to misconstrue or try to twist it and turn it into something that it wasn't until now, right? Defendants, nobody ever had a problem. Nobody ever had a problem with me taking pictures of my children and everybody else's in the ball game. Nobody had a problem with that. All the other parents take all their pictures and post them too. Why am I any different, right? Defendants imposed and continue to enforce a sweeping district-wide ban, excluding plaintiff, who's a parent, from all school property and all school-sponsored events without due process and in retaliation for protected speech. Number 5. Jurisdiction exists under, and then it has the statute numbers there. Declaratory and injunctive relief are authorized, and then it has the numbers, statute numbers. Venue is proper under, and then it has the numbers. So the parties: plaintiff, Elizabeth, me, and I am the parent of children enrolled in, Elizabeth Jones is a resident of, and I am the parent of children who are enrolled in Jenkins School District. Number 9, defendant Jenkins Independent School District is a Kentucky public school district. And so it is a person under the 1983, whatever that is. Number 10, defendant Damian Johnson is the superintendent of Jenkins. Number 11, defendant Rondell Baker. He's the assistant superintendent. He was one of the ones that came to my door. Him and the school resource officer. Number 12, defendant Alicia Congleton is a school resource officer employed by or assigned to Jenkins. And y'all have heard me many times say that we just adore Alicia. We've always liked Alicia. So this is a very awkward thing. But, I didn't put Alicia in this position. School did, not me. Number 13, defendants Chris Bentley, who's also our mailman, who I had absolutely no idea he was also the mailman. And do you know how nice that man has been to me all this time? Just nice, and all up in my face. And I didn't know his name, and I didn't know who he was. And this whole time he was just nice, and right to my face. And then as soon as he'd get behind my back, just I see that. That's nice. All right. Defendant Timothy Crawford. Now, he was the school attorney, the school board attorney who they used for this ban, who we found he gives lots of ban letters to people around the state of Kentucky. It appears that this attorney is used just for these kinds of things, just for like bans and stuff. I would like to know if Timothy Crawford was he the lawyer for the school board prior to them getting him to do the ban? I don't know, but I'd like to know that information. All right, factual allegations. A, plaintiff's status as a parent. Number 15. Plaintiff is the mother of minor children who are enrolled in and attend schools operated by Jenkins. For several years prior to the events at issue, plaintiff regularly attended school-sponsored events involving her children, including athletic events, ceremonies, and other activities open to parents and the public. Number 17, plaintiff's attendance at such events was peaceful, lawful, and without incident. I have never had the first incident at the school, ever. Number 18, prior to receiving the December 15th, 25 ban letter, plaintiff was never accused of any violence, threats, disorderly conduct, trespass, or violation of school policy or criminal law while on school property. Never. Number 19, plaintiff has a recognized liberty interest protected by the 14th Amendment in participating in her children's education and school life, including attending events involving her children. I am the only one that's ever went to their ball games, ain't I, Mom?
That's right.
Have you ever went to their ball games other than just a handful?
Who, me?
Yeah.
No,
Yeah.
I don't. I don't
Okay.
go to ball games. I should, but I don't.
And Willie? Has Willie ever went to the boys' ball games?
He don't go either.
Mm-mm. Nobody goes but me, do they?
That's right, just you.
And I have not missed a ball game, except unless I was working. Unless I had to work, I did not miss a game, whether it was home or away. If the only time I ever missed a game was if I was working. So that means I was at and I was at all the practices. Now, same deal. If I had to go up there and drop them off at practice and then go back to work. But a lot of times I stayed. I went to practice and I stayed and I watched practice. I have always been a very, very active ball parent. I have spent thousands and thousands of dollars on concession stand items that I then donated. You know, you go to the store, spend $300 on Gatorade, water, hot dogs, stuff like that, big cans of cheese and chili and stuff, and take it down there and donate it to or give it to the concession stand, give it to the team. I can't tell you how many times I've done that for baseball, basketball, football, you name it, cross country. My kids are athletes. What they've done here is wrong. Number 27. The letter failed to identify any specific post, student, date, conduct, policy, or law allegedly violated. I'm going to pull this up too real quick. Well, I'll have to pull it up this other way. Let's finish this one first. All right. We're going to look at the letter, the ban letter. And I'm going to show you and prove to you that what Newspaper Man put on his post was false. And it's very easy. I mean, I don't know why he put that on there. That ain't true. And it's very easy. I mean, the ban letter is 1 page. The ban letter is 1 page. So it's not like he got that information misconstrued somewhere. That was a falsehood. That was just a flat out. I don't know where he got that from. It was very easily. It was very easily confirmable. Like all he had to do was read the letter. So, anyway, that upsets me that he has told that falsehood like that, because I think he didn't want to catch heat over using that picture. So he was trying to cover his butt, maybe. I don't know, but that sure ain't true. Number 28, the letter did not allege the plaintiff made any threats, engaged in any violence, disrupted, trespassed, or violated any criminal statute. 27, the letter failed to identify any specific post, student, date, conduct, policy, or law allegedly violated. Number 29, the letter did not cite any school board policy. No policy. No administrative regulation or law. Number 30, the letter imposed a district-wide ban on all property owned or leased by Jenkins and from all school-sponsored activities without limitation or as to time, place, or manner. I mean, have y'all ever heard anything like this in your life? I haven't. And for them to put it in writing and be so proud to hand you that in writing, it just blows me away. Number 30, I already read that one. 31, the letter did not state whether the ban was temporary or permanent and did not state any duration. It was just I got 6 more years. My kids have 6 more years at that school. 32, there were no copies of the letter. I don't know. It says 32 copies of the letter. Okay. Number 33. The letter there were copies of the letter. There were copies of the letter because copies of that letter went to the school resource officer. It went to the copies went to the principal at the grade school and the school resource officer at the grade school. It also went up there at the high school. So there were copies of this letter that were sent out to all Jenkins school properties. So they were making sure that this SR officer down here and this principal down here, if I showed up on their property, they were wanting to make sure that they were aware of this ban. Number 33, the letter provided no notice of any kind of hearing, either before or after the ban was imposed, and no opportunity for the plaintiff to respond to any allegations. Number 34, the letter further warned that if plaintiff were present on any school property or at any school-sponsored activity, she would be removed by law enforcement. So yes, I was threatened to be removed by law enforcement, and that the school district would seek criminal trespass charges against me. So that now they're threatening me with arrest. Number 35. The letter referenced generalized concerns about safety and well-being, but did not allege any specific safety incident involving the plaintiff, me, because there's never been one. Number 36, at no time did defendants issue plaintiff a warning, impose a time-limited restriction, restrict plaintiff from any specific location or event, or consider any less restrictive alternative prior to imposing the district-wide ban. Number 37, defendants made no finding, written or otherwise, that plaintiff's speech caused any actual or material disruption of school operation. Number 38, at no time prior to receipt of the letter was plaintiff notified that she was even under investigation, accused of any kind of misconduct, or subject to potential exclusion from school property or school-sponsored events. Number 39, at no time prior to or following receipt of the letter was plaintiff afforded any opportunity to contest the allegations or present her side of the story. Number 40, defendants have treated the letter as immediately effective and continue to enforce the ban against plaintiff. Number 41, copies of the letter were distributed to the superintendent, principals, and school resource officers, reflecting the district-wide implementation and enforcement. D, lack of due process and enforcement. Number 42, prior to receipt of the letter, plaintiff was never notified that she was under investigation or subject to exclusion from school property. Number 43, plaintiff was never afforded a hearing or opportunity to be heard before or after the ban. Defendants have treated it, and then it kind of just repeats everything. Public forum allegations, school-sponsored athletic events, extracurricular activities, and other school events that are open to parents and members of the public constitute, at minimum, a limited public forum for purposes of the First Amendment. In a limited public forum, government officials may not exclude individuals based on viewpoint and may not impose restrictions that are unreasonable in light of the forum's purpose. And she cites specific case law that backs all this up. 48, defendants excluded plaintiff from these limited public forums through a district-wide ban without any individualized assessment, time limitation, narrowly tailored justification, or procedural safeguards. Knowledge, ratification, and policy. Defendant Damian Johnson, the superintendent, knew or reasonably should have known of the ban, and he failed to intervene. It's just how we had to write it. Defendants Chris Bentley, Paulette Sexton, Sarah Brown. Some of these people used to be my friends. They are no longer. They never were my friends. They were never my friend. Never. Sarah Brown, Charlotte Mullins, and Patrick Sturgill as members of the Jenkins Board of Education, and final policymakers knew or reasonably should have known of this ban, and they failed to rescind it or provide procedural safeguards. 51, and then we talk about Timothy Crawford. As board counsel, he participated in authorizing, approving, or ratifying the ban and its enforcement. Defendant's conduct reflects official policy, custom, or ratification sufficient to impose municipal liability. Ongoing and irreparable harm. The ban remains in effect. Plaintiff continues to be deprived of her ability to attend her children's school event. Plaintiff's First Amendment rights are chilled by the threat of law enforcement and criminal prosecution. So that means I don't speak things that I normally would speak out of fear of retaliation, right? They can't chill your speech. Number 56, defendants have provided plaintiff with no mechanism by which the ban may be reviewed, modified, or rescinded, rendering this exclusion indefinite in duration, meaning there's no way to even look at, review it, or anything. They've just blanketed. Number 57, the loss of First Amendment freedoms constitutes irreparable injury. Number 58, monetary damages alone cannot remedy the ongoing constitutional violations. 59, plaintiff incorporates the preceding paragraph as if fully set wherein protected speech. 60, plaintiff engaged in protective speech within the meaning of the First Amendment, including lawful off-campus speech and online speech expressed through social media posts. 61, plaintiff's speech occurred outside of school property, was not school-sponsored, and did not occur during any school event. 62, plaintiff's speech did not involve threats, incitement to violence, or unlawful conduct, and did not materially disrupt school operations. 63, speech communicated through social media platforms is fully protected by the First Amendment. 64, plaintiff's speech therefore falls squarely within the core protections of the First Amendment. Adverse actions. 65. Defendants took adverse action against plaintiff by imposing and enforcing this district-wide ban. All property, and then it kind of just goes back through. Okay, so I'm not going to finish reading all of this. It's basically the exact same thing over and over and over again. And it's a lot of case law. You see how many pages this is? This is a huge lawsuit, okay? It really is. And what we asked was for the judge to do this restraining order. We asked for him or the judge to lift the ban before the 8th grade night. That's what we were trying to get done. But like I said, I didn't know the date. I didn't put the date in there. And so we screwed up on that part. But here is, let's see. Let me get the TRO denial first. We want to read this one first. So this is the one that the judge wrote. This is the memorandum opinion and order. Okay. And this says that this matter is before the court on plaintiff Elizabeth Jones' motion for the TRO, the temporary restraining order, and motion for the preliminary injunction. Because Jones fails to satisfy the requirements of Federal Rule of Civil Procedure, her request for a TRO is denied. The court will continue analysis of plaintiff's motion for preliminary injunction after a scheduling conference has been held and additional briefing has been filed. So we have to do that. Plaintiff is a resident, and then, okay, as a mother, Jones regularly attended school-sponsored events that involved her children including athletic events, ceremonies, and other school events. Like many Americans, Jones regularly posts on social media. Like many Americans, Jones states that she engages in lawful protected speech on matters of public concern, including criticism of national and local elected officials, advocacy for students and parents, and public commentary protected by the First Amendment of the United States Constitution. On December 15th, 25, Jones received a visit from two JSID employees at her home. Defendants Alicia Congleton, a school resource officer, and Assistant Superintendent Rondell Baker delivered a letter to Jones. This letter, drafted by defendant Timothy Crawford, banned Jones from entering any and all properties owned or leased by this school district and from attending any and all activities sponsored for and by this district. The letter further warns that if Jones is present on any property owned or leased by this school district, they will have her removed by law enforcement, and the school district will seek criminal trespasses charges against you. Crawford and he had the judge put this in quotes. Crawford justified this ban based on multiple posts on social media. This is it. This line right here. Now, I don't know where Newspaper Man gets that picture from as the basis for this ban letter, because that is not stated anywhere. So I don't know where Newspaper Man came up with that. But here it is, quote, multiple posts on social media of students participating in extracurricular activities which appear to be harassment and which have caused disruptions of the educational process in this school district. That's it. Quote, unquote. They never say which post. They never say anything specific, nothing. They just say, due to multiple posts on social media of students participating in extracurricular activities, which appear to be harassment. Now, I've been taking pictures for almost 10 years of our sports activities. Never once been accused of it being harassment. Not one time, ever. So I don't know where you got your info there, Newspaper Man. You might need to correct that if you're the, beacon of truth. On January 5th, 26, Jones filed her complaint in the Eastern District of Kentucky. Her complaint alleges 6 counts, including claims of First Amendment retaliation, procedural and substantive due process violations, and municipal liability. Jones also seeks declaratory and injunctive relief against the defendants. On the same day, Jones filed a motion for the TRO. In support of her motion, Jones argues that she continues to be excluded from her children's school events. This is where I didn't have the right information in there. I didn't know the date of 8th grade night. Nobody would tell me. I asked a couple times. I guess I should have digged a little bit deeper on my own. But I asked several people, and they said, no, I don't know. And it's before the end of the month. That's all I was told. It's before the end of the month. But I didn't know that I needed a specific date in this lawsuit. So, note to self, and for anybody else out there who tries to file a motion for something like that, You need the date. You need that extra information in there. And Jenny, there was something she didn't do. Let's see. On the same day, in support of her motion, Jones argues that she continues to be excluded and remains subject to the threat of arrest and prosecution. Jones further argues that because defendants have provided plaintiff with no mechanism by which the ban may be reviewed, modified, or rescinded, the ban is de facto indefinite and that monetary damages cannot remedy these harms. In counsel, I missed his 8th grade night. Mommy had to go in my place, and it wasn't the same. It wasn't the same at all. I mean, I'm grateful that Mommy went, but, that wasn't special to Gregory. That should have been me. I'm the only one that's ever been to all of his stuff. You know how that makes me feel that I was, you can't let them see you sweat. You can't let them know that they hurt you, because that's what that's what I feel like people want to see, that you're hurt. But all I do is look at the picture of Gregory and I see the look on his face, and that says enough. Jones further argues, counsel provides a signed declaration by Jones indicating that she understands that my attorney provided advance notice by electronic mail to counsel for Jenkins of the intent to seek emergency injunctive relief prior to filing the motion for temporary restraining order. The question of whether to issue a temporary restraining order against the defendants is ready for review by this court. Federal rule governs the issuance of temporary restraining orders and preliminary injunctions. The purpose of this order is to review Jones's motion for the temporary restraining order. A temporary restraining order is an extraordinary remedy designed for the limited purpose of preserving the status quo pending further proceedings on the merits. It is considered a rare and extraordinary remedy because our entire jurisprudence runs counter to the notion of court action taken before reasonable notice and an opportunity to be heard has been granted both sides of a dispute. So what that means is that a TRO is granted in very, very rarest of circumstances. It's usually not granted, I don't think. That's how I read that. And we didn't have the criteria in there. We missed it. But, like I said, lesson learned. But that's just for the TRO. And then it explains it down here. I'll skip past all of that. And we'll get down here to where it explains that it doesn't really matter. Okay. Jones has not made the required showing that immediate or irreparable injury will occur before the defendants have the opportunity to respond. See, I didn't put the date in there. That is what was so important. That's what we missed. Jones has not made the required showing that immediate irreparable injury will occur before the defendants have the opportunity to respond. See, I only had a month. There was maybe 2 weeks between the time I filed the civil suit and the 8th grade night. There was only like a week or week and a half, 2 week window there. And I didn't know specifically what day it was on, so we didn't get it in the lawsuit. So we missed that required showing. All right. Further, Jones's counsel, which is our Jenny, I love my Jenny, has not certified in writing any efforts made to give notice to the defendants, nor listed reasons why notice should be required. We missed that too. But Jones herself did submit a signed declaration asserting that her attorney provided notice to the defendants, but nowhere in the memo of support does Jones's counsel, Jenny, describe counsel's efforts to give notice as required by the federal rules. All of these details matter, you guys. Jones argues that she continues to be excluded from her children's school events and from public forums open to other parents. But it is not clear to the court that this is an irreparable injury warranting the entry of a TRO, the temporary restraining order, where it is unclear whether the defendants received notice and where they have not made an appearance in this case. Additionally, a TRO is just that, temporary. Now, this right here is what made me feel so much better. A temporary restraining order lasts only for 14 days, which expires unless the court finds good cause to extend it or the opposing party consents to the extension. Any relief sought by Jones would be temporary, so it would only last 14 days anyway. And then I guess the ban would go back in place unless the judge lifted it completely, which, like we said, it's very, very rare that happens until before a hearing. So that's the only thing that's happened. He denied it prior to the hearing. We still get to go have this court hearing, and and he will I guess rule on lifting it or not lifting it. And it's all up to the judge, honey. But okay. Additionally, a TRO is just that, temporary, any relief. Okay. Any relief sought by Jones would be temporary, and associated filings justifying an extension of the order would burden the parties and the court and could delay resolution of Jones's preliminary injunction motion. So it's a good thing that they denied it. I mean, that was what was best for me anyway. The court will therefore deny Jones's motion for a TRO because she has not met the requirements of Rule 65, warranting the entry of such an order against the defendants. The court will, however, order expedited briefing as to the preliminary injunction after the appearance of all defendants. So he's ordered an expedited briefing as to the injunction after we've all appeared, or after all the defendants have appeared. At that time, the court will determine whether a hearing and limited expedited discovery is appropriate. As such, this denial of Jones's motion for a TRO does not disturb Jones's outstanding prayer for relief in the form of a preliminary injunction. So do you see that? Did you hear that, Mommy?
I heard that.
Accordingly, the court, being so advised, it is hereby ordered that the plaintiff Jones's motion for the TRO is denied. And that was the 12th day of January. And that was the judge, Van Tatenhove. Van Tatenhove. Is that how you pronounce that? Can you see it?
I don't know how to pronounce it.
Okay. So then here is the lawyer, the school board's attorney. He put in a motion to dismiss. It was granted. He was dismissed from the lawsuit, but we had to do it. That's okay. We knew it was coming. In his official and individual capacity, he put in this motion to dismiss. Huh?
No, I'm sorry. I was talking to Willie.
Oh, okay. Background. Plaintiff alleges that the following in her complaint: that the Jenkins School Board banned plaintiff Elizabeth Jones from all properties. The letter stated that the ban was due to Jones's social media posts, which harassed children, disrupted the educational process, and jeopardized the safety and well-being of students, fans, and visitors of school property. All anybody has to do is look at my Facebook page. Now, Mommy, do you think that I have ever done those things?
Well, no, I don't think so.
Thank you.
But
Jones?
it don't matter what I think.
I know, but still, I wanted to hear it.
And it's not about what they say it's about. It's more of a grudge kind of a thing.
Well, this also, we missed this too. Federal Rule of Civil Procedure provides for dismissal for failure to state a claim upon which relief can be granted. To survive a motion to dismiss, a complaint must contain sufficient facts, when taken as true, state a claim for relief that is plausible on its face. And then it gives the court precedent. A claim is plausible if the complaint includes sufficient facts for the court to infer that the defendant is responsible for the alleged conduct. The complaint must contain either direct or inferential allegations respecting all material elements necessary for recovery under a viable legal theory. Moreover, the complaint is accepted as true, reviewed in the light most favorable to the plaintiff, and all reasonable inferences are drawn in the plaintiff's favor. This assumption applies only to factual allegations. A plaintiff's legal conclusions are not entitled to assumption. The courts are not bound to accept as legal or as true a legal conclusion couched as a factual allegation. And then basically the reason, let's see, let me pull up the, this was just his argument, okay? This was just the motion to dismiss. So the lawyer put this in. In Polk County v. Dodson, the Supreme Court held that a lawyer representing a client is not, by virtue of being an officer of the court, a state actor under color of state law within the meaning of 1983. So that's what it was actually granted on, was that 1983, I think. Let's see. Oh, I keep pushing image file. I was pushing the wrong button. All right, now here is the letter. Okay, we wanted to look at this letter. All it boils down to, they're trying to keep Elizabeth quiet and get rid of her show because she's spilling the truth about corruption. Oh, yeah. All right, sorry, y'all. I was focused in on all this. Frosty says, I remember that Harper Valley PTA song. I don't know how it goes. Do you remember how it goes, Mom?
No. I remember it's Harper Valley PTA. It's not my kind of songs, you know.
Yeah. Here is the letter. Okay. Nowhere in this letter does it say anything about that picture of Lila Steins in the background behind us. Says, Dear Miss Jones, due to your multiple posts on social media of students participating in extracurricular activities. Now, I mean, what parents don't post about I didn't know just posting about extracurricular activities was harassment, which appear to be harassment, they say, and which have caused disruptions of the educational process in the school district. You are banned from any and all properties owned or leased by the school district and banned from any and all activities sponsored for or by the school district. Now, have you heard anything about that picture yet? No. It is of utmost importance to provide for the safety and well-being of our students, our fans, our visitors, and those who use the school district facilities and attend school district activities. Just everybody but me. They had everybody but me. Everybody's welcome but me. Oh, Jesus, Lord, help me. It is of utmost importance to provide for the safety and well-being of our students. Oh, I already read that, didn't I? Our fans, our visitors, and those who use the school district facilities and attend school district activities. If you are present on any property owned or leased by the school district, or are present at activities sponsored by or for this school district, the school district will have you removed by law enforcement, and then the school district will seek criminal trespass charges against you. We look forward to your expected cooperation, and with kindest personal regards. What do you think, Arizona?
Well, I just think it's a bunch of lawyer speak, you know, for the courts, and it don't amount to a hill of billions because some of it is
it's unconstitutional. They can't do that.
It's just ridiculous.
I'm not here to speculate about the outcomes. Everything that we talked about tonight came straight from these public court records. Emotion is not a finding. I already said that. An order doesn't always mean what headlines make it sound like. Let's see. It's really bothered me. This whole thing has bothered me a whole lot. But
Well, it's sort of obvious that it has, and I guess you can't help it bothering you, but I wish you could move past it.
well, I mean, I do the best I can. I don't sit in here and cry and carry on. I just go to work. I just go to work. I do what I got to do at work. We've got this lawsuit filed, and it's in God's hands. Those allegations are what triggered this lawsuit. We got a long way to go. I've been praying for a long time that the Lord would open doors, certain doors. I didn't know what doors He was going to open. Didn't even know what I was praying for, to be honest with you. I was just praying that whatever doors were in His will for me, that He would open them. And this is the path that He's led me down. It sure ain't been my decisions that have gotten me here. It's been doors that He's opened and doors that He has closed. My very best friend in the whole world, well, I'll just move on past that. So anyway, but now that we've set the table here with this lawsuit, we're going to start, learning. We're just going to have to learn about this stuff, because so many other people, the more of these that we learn and we read through and we learn the process for, the more we're going to be able to help for future lawsuits. Knowing what you're doing, experience. There's no substitute for experience. And there's no substitute for failure. Failure, a lot of times, has taught me more. All the time. My failure taught me more than any of my successes ever have. So that was the verified complaint. To explain the First Amendment and due process. Every due process, I know you guys have heard that a lot. But I don't know about a lot, but we all have the right to due process. Let's see. After filing the complaint here, my attorney also filed that request for the TRO. Now, that is an emergency relief. It asks the court to act before the other side even responds. The judge denied that, not because the case lacked any merit, but because the legal standard for emergency relief wasn't met at that stage. Now, the court did not decide whether the ban itself is constitutional. That will come later. One defendant, the school district's attorney, filed that motion to dismiss, but it was only against him personally. Did not affect the lawsuit against the school board, the superintendent, the assistant superintendent, and the SRO. This dismissal was based on legal doctrine, specifically whether a private attorney counts as a state actor under federal civil rights law. This ruling did not address the school district's conduct at all. let's see. Are you able to physically attend away games? Yes, I go to the away games, and which basketball's over now, but baseball is getting ready to start. In the next month, we'll have practice. Probably in the next few weeks, they'll start practice. I know they'll definitely start working up at the gym and stuff like that. But I can't even go on the property to drop my kids off in the morning and pick them up in the afternoon, or drop them off at the away for the bus to go on their away games, to pick them up whenever come back at midnight. No, they make the kids walk across a big highway. I have to park on the other side of a highway, and the kids have to walk across. They have to walk from the school down through the parking lot and across the highway to where I park across the road. And even at midnight, and I'm still the team Uber. So half of the team, whether it's cross country, basketball, baseball, it don't matter. Half of the team would not be there if it weren't for me. So when I take my two to go to practice, I usually have to stop and go pick all the other ones up. And it depends during which day. One day I might just have to pick one up. One day I might not pick none up. But then I might drop 5 of them off at home after practice. Or I might pick 3 of them up before practice and drop 3 of them off after practice. Or I'll drop 3 of them or pick 3 of them up, and we'll bring them up and they'll stay with us that night. You know, I mean, they would have to probably forfeit a game if half the team wasn't there. How are they going to get there? The coaches ain't going to go pick them up. No, they ain't. And a lot of these ball parents work. If it wasn't for me picking up their kids or dropping them off, they wouldn't be there. So it sure ain't going to have no other parents doing it. And if they do, it's only going to be sometimes. It ain't going to be every day like I do it. The day after they banned me, the day after they served me with this ban letter, we went to an away game. The bus took the kids to the ball game, dropped them off at the school, and then the bus driver left with the bus. And so the coach said, "Hey, Liz, come here. We don't have a bus driver. You think you can help us get these kids home?" And I said, "Why, yeah, you know it." So the school hates me so bad, but yet they'll send half the ball team in my vehicle for me to get them home from an away game. They still depend on me as the team Uber driver. And I've stopped buying all the concession stand stuff. Yeah, I haven't done that in a while. They sure took a $500 check from me 2 or 3 years ago to start the baseball team with. Our baseball team had 0 in the account. And so I wrote a $500 check and gave it to Paul Whitaker, Judge Nick Whitaker's brother, Coach Paul Whitaker. I gave him a $500 check and said, "Here, go get our season started, Coach." They took all this money from me, but they sure wouldn't take which I didn't ask for it. They sure weren't going to take no picture of me and put it up on Facebook. They weren't going to never mention nothing that I've ever donated. Nope. That's all right, though, because that's not why I do it. I see people telling him hi, but I don't see his name. What am I saying? I don't know, Philip. I'm sorry. I jumped in there and don't know what even going on. Well, my kids don't want to leave Jenkins. I know people have said leave, leave, leave. But my kids don't want to leave Jenkins. Miss Mary Kelly, bless you, bless you, bless you, honey. Thank you so much. Ronald Northwick, bless you, bless you, bless you. Thank you, thank you, thank you. Dave, love you, honey. 5 Hillbilly Crime membership. If you got you a membership tonight, make sure you thank Dave. We've got a goal in the chat tonight, y'all. 10 $5 supers. If we hit the goal, it'll make confetti go all over the place. It's kind of fun. But we got to hit the goal first. But that's all right. One of these days we will. One of these days we will. Oh, it's saying the comments you made on the posts are harassment. No, I don't think so, because I didn't say any comments. That's not what it says on there. Due to your multiple posts on social media of students participating in extracurricular activities. I mean, we can only go by what's on this letter, like I noticed that the wording was a little bit different in the attorney's motion to dismiss. He kind of worded it a little bit more aggressive, made me sound a whole lot worse, than what I am. And remember, they're not identifying anything specific in here. And where's the due process? People can't just accuse you of something. There has to be a policy. Like the school would have to have a social media policy or a photograph policy already in place that says you're not allowed to do this, you're not allowed to do that. These are the guidelines, these are the policies, and we don't have any of that. We don't have any of that. There's no difference between me taking pictures of these kids and anybody else. Like there's other photographers that go up there and take pictures of these kids, and then they take them home, put it on their own Facebook pages. Here we go. Let's see. Let me show you. Well, here, I'll pull it up this way and show you. There's several. There's 3 men, and I'm the only woman that I know of that has done photography, sports photography at Jenkins, and remember, my kids have been there for 5 years, and I've been doing this the whole time that we've been there. And there was never nobody else out there at these ball games taking pictures except for Chris Anderson. Now, Chris Anderson has always had the gigs. Chris used to be one of my friends. I don't know if he's still my friend or not. I've lost a whole lot of friends. People who thought were my friends. Now, these are my pictures. Here we go. This is an example of the photos that I take. That's it. That is it. Let me pull up an example. Now, I just take these pictures and post them. And for the last 10 years, I have been taking, I take a ton. Like it'll let you upload 80 pictures at a time. And I would put up like 4 sets. I'd put up about 4 sets of 80. Now, here's the Jenkins Independent School. Here's their post that they did. They didn't want me in their picture. They didn't want to have to post me on the Facebook page, I guess. Boys basketball and cheer 8th grade night. A huge thank you to Prime Time Visuals for the awesome pictures of our 8th graders and for capturing such special moments. Congratulations to our boys basketball. This is the night that they banned me from. This was my son is in one of these pictures with Sweet Tater. For capturing such special moments. Congratulations to the boys basketball on a big win and an outstanding season. Also, congrats to our amazing cheer squad. We're proud of the hard work, dedication, and growth shown by these teams all year long. Okay. So there is an example of the school encouraging and sharing and highlighting another photographer at Jenkins, who also happens to be the D team coach. Yeah, he's the D team basketball coach. And the day after my ban, the day after they served me with the ban letter, he launched his photography business at Jenkins the next day. So I was not there. I was banned. I was not allowed to be there to take any pictures. And I put mine up for free. These people, these men who are encouraged and allowed to do it, they take their pictures home and put their watermark over them, and then they sell them on their websites and their Facebook pages. So here's one. This is Prime Play Visuals. So this was I think this was the night. Yeah, this was the night that I was banned. I wasn't allowed to be there to take any of these pictures, but you see, he was. And so he took all these pictures. Now, what's the difference? Do y'all see any difference? Oh, yeah, they post my kid on social media. This is the D team coach. The day they sent me, they sent me my ban letter that I'm not allowed to be there to take pictures no more. The next day, he launches this website on Facebook. Prime Play Visuals. Oh, we ain't done. We ain't done. Here is another one. This is East Kentucky photography. How is this any different? These are his pictures. So he can come to the basketball court. He can take all these pictures and go home and slap his watermark on them and put them up on his Facebook, and then so yeah, they're selling theirs, but I was just given mine. I was just posting mine because a lot of people in this area are poor and they can't afford to be given Ernie Sexton a big bunch of money for a picture, or even the other one, Prime Play Visuals. No. They're allowed to do it. They're allowed to do whatever they want, picture-wise. Do y'all see any difference? Eliminate the competition? You reckon? Arkansas Emmy. I do not understand all of this. I thought that to stop someone from a public place, they had to cite the specifics of what you did. I have yet to see the specifics. Thank you. Thank you. Yeah. If they want to shut her out of the school and being at her son's events, it has to be more than they just don't like me. I also thought that they had to be specific on what she did. Well, that's why we filed a lawsuit. That is why we filed the lawsuit. Yes, Philip. No, honey. No. They ain't none of my friends. Never was. Lovely pics. Thank you. Thank you, thank you, thank you. But there you go. That is an example of what, I'm fighting what I'm fighting against. This is what we're fighting against. Because you don't like me. I just don't know. Please name the complaining party. Well, I guess it would be Jenkins. Screenshots he sent me was nothing. It actually proves what Elizabeth is saying. They're causing problems over nothing. They're doing this because she's pointing out corruption. So there was, let me see if I can. There was a see what post was it? There was a photo. Okay, so we had a ball game. I don't know, a couple months ago, and we played against this other team, South Perry. Well, 3/4 of the way through the ball game, the head coach, okay, 3/4 of the way through the ball game, you've got fans over on the other side, and the other team's fans start getting pretty nasty. I'm all the way up on the top on the other side with my camera, just taking pictures and video. I wasn't around nobody. I was not involved in any of this. I've never been involved in anything. I'm always up on the top taking pictures, or in the middle taking pictures. I've always got my face in a camera. Well, our referee ends up throwing some of their people out, some of their fans out. And I got some pictures of it. I got pictures of our coach walking across the court and them kicking them out. That's it. I posted them. So what? There's always somebody getting kicked out of a ball game, but they don't ever get banned. But a ton of them get kicked out. 3/4 of the way after that, about 3/4 of the way through the ball game, our refs have to stop the game because, I don't know, the other team just kept getting worse and worse and worse. So our refs call the game 3/4 of the way through. Game's over, game's done. And I didn't even know I got the pictures until I got home and started editing them, put them up on my computer to see what all I got. I didn't even know I had it. Got the coach flipping the bird. It's the wrong finger. He's in the middle of the court, flipping the bird to everybody on our side of the gym. He's got his students, his basketball players are going, acting like they're going to beat up our kids, stuff. I posted a picture of the of the coach with these flipping the bird up in the middle of the air. I posted that picture. I don't know anything about these kids. I don't know anything about that. I don't know anything about nothing. All I said was, thanks, coach. I don't know why this middle schooler with a mustache is acting like he wants to pummel all of our kids. Well, somebody got offended because I said a middle schooler with a mustache. Well, he's a middle schooler and he had a mustache. That was an observation. That wasn't no kind of dig. I didn't say anything bad. Well, so what? So what? Who cares? Somebody said, oh, well, he's a cancer survivor and da-da-da-da. Okay. I didn't ask that. I didn't say anything about that. So, of course, somebody blew it up way out of proportion. But that ain't my fault. That ain't got nothing to do with me. Just because I happened to catch the coach flipping everybody off. Seems to me like maybe the coach and that behavior was what was disrupting the process. It wasn't me capturing it in a picture. I'm telling you, it's just the most insane kind of logic, and that these people are our educators. These are our education administrators. These are who are teaching our children that it's okay to waste money. Because now you all have put the entire school district at risk. A whole group of people. Well, that just shows you that they all acted as a body. But yeah, the coach was acting worse than a child he was. But it wasn't my fault. I didn't have nothing to do with it. And then we had another photo that I took, and it was of one of our D team players. Here's one. I'll show this one. It was something like this. It was very similar to something like this. It was a tip-off picture, and it was one of our kids and one of Dorton's kids. And Dorton's kid was about a foot higher than ours in the tip-off. And so I put the picture up, and it was a great photo. I mean, it's a great photo. And I said, man, who else's kid acts like every play is they're in the NBA? You know, like, I wanted to make our kid feel better because he didn't get as high as the other kid did. That's all I said. And I tagged our mom, our ball mom, that kid's ball mom, in the photo when I shared it. And nothing was said about it. 2 weeks later, or 3 weeks, or a month later, the other kid that was in the tip-off, the one that was up top, his mom sees the photo, and she just raises hell. Says that I'm making fun of her kid, and how dare I need stopped. That Elizabeth and her hillbilly crime making fun of kids. She needs stopped. Are you kidding me? Like, you really need help. You need some help. Because that is nothing even close to what reality is. And God sees it all, honey. God sees it all. HB Sue, there's nothing about this that makes sense. No, it doesn't. Would you be allowed in if you didn't record or take pics? No. That's a violation of free speech, constitutional rights, freedom of the press, right? Yeah, and due process, because I was not given any kind of hearing. There was not any kind of anything. Like, they just decided it and threw this ban, and they're not allowed to do that. Like, due process, we have the right to due process. It's like you getting arrested and them skipping your trial. They're just going to arrest you and say you're guilty, and you're going to prison. And you don't get a trial, you don't get a hearing, you don't get a pretrial, you don't get an arraignment, you don't get nothing. Do not pass go, do not collect $200. Just go directly to jail. We live in America, y'all. We live in the United States of America. And I have never been more disappointed, I think, throughout this last few years, in our educational system. I'm going to say that. My disappointment's in our education system, because how many people do you know even knows what our constitutional rights are? Since I've been a content creator, the amount of wrong beliefs, like people really believe certain things when it comes to social media and stuff, and it just blows me away. Freedom of speech. Well, that would be a really good fun thing to do is go around and ask people what they think freedom of speech really means. Man, we get some really, really good answers. We get a lot of different answers. I'm going to do that. I'm going to do that. Let's see. I never one of them. They don't like, yeah. And ain't none of it makes a bit of sense. That's the picture I was sent along with your comment. Which picture? The other one that, or are you talking about that one? Well, even if I do say something and it comes off wrong, what's that? That doesn't mean that you get banned. I mean, that's even more of a free speech argument. I'm sure I'm not the only one that's ever said something and somebody took it wrong. William, I was 18 before I had decent facial hair. Honey, we got some cornbread fed boys up in Appalachia. Yeah. Well, we had a kid it was like the very next week that had a full beard. So you had this kid that had the big old mustache, and then you had another one the next week that had a big old beard. I mean, it was full sideburns and chin and all. Philip says some of us males grow facial hair sooner than others. I know I did a mustache in 5th grade. My Gregory's got one now. But he is a little bit older than 5th grade, though. Kids nowadays have beards. They do. Well, it's not just nowadays. Somebody was telling me that back when they were in school, look at the difference in the physique, in the bodies of these kids. Back, like when I'm almost 50, so 30 years ago. A lot of these pictures that I see of these kids back then, like they were brutes. They were beasts. I wonder if maybe they ate better. Soup beans and cornbread and stuff like that. And now kids eat a bunch of junk. So I don't know. I don't know if they just don't seem to be as brute big and cornbread fed is what they used to be 30 years ago. But I could be wrong. Yeah, this ain't the picture here. If you want to scan the QR code up in the corner of the screen, that will take you to my Facebook page. Just go to the Facebook and go look through the photos, look through the reels. You're going to see it all. I've had that account for 17 years now. It's the exact same account that I started when, right around the time I started my recovery journey. I may have even started it a little bit before. But it's the exact same account. So you can watch my story. You can watch the progression of our story from the time that I had the boys until now. It's the exact same Facebook page. And you can see the photos, all the sports photos that I've taken for the last 10 years are all on this account. And you'll see that there's never been a problem. Not one. Mary Kelly. These people are a little jealous, petty people. Remember, they nailed Jesus to the cross because they were afraid of him and his followers. You know they are going to persecute any more. Amen. Amen, Miss Mary. Amen. And listen, just because we were talking about a mustache and a beard, we're not making fun of nobody. I mean, what, we can't laugh about it just because we giggle and laugh talking about kids having facial hair in 5th grade. I mean, that's not making fun of people. I have also this whole hillbilly crime journey, so many people that are the first to holler about a bully. They're the first ones to I don't know what's the word I'm looking for. They'll call out a bully. They will report that they're being bullied. They'll, you know what I mean? First person to holler about a bully. How many of those people have I seen turn into them? Same people hollering about them are the exact crits that turn around and try to bully me, try to bully Ben, our little friend Ben. He's been going through it, son. He has been going through it by a lot of people who most would be really surprised are even involved in bullying him. He's a child. I'm almost 50 years old. I can handle myself. I can take up for myself. A 16-year-old child, he does a pretty good job handling these, taking up for himself, but he shouldn't have to. 16-year-old shouldn't have to. No. They didn't throw out my case. No. They just dismissed it from, they dismissed the lawyer because we had to name the lawyer in it, and which we knew that they would dismiss it on him. It's procedure. So civil cases are all procedural, and we're learning. But like I said, the TRO, even if they would have, if we would have done all the things that we were supposed to do, even if they would have approved it or whatever, I guess approved it, granted it, it would have only lasted for 14 days. And then I guess the ban would have went back into effect. So it would have only been temporary, which that's all I needed. I only needed that one night for 8th grade night, but didn't get it. That's all right. It's all right. And my kids do not want to leave Jenkins School. They like their teachers. They shouldn't have to. They shouldn't have to. Kids shouldn't be, children should not be run out of a school just because they don't like the kid's parents' job. I don't like people's job either. I don't like their job performance. They don't give a damn if I like it or not. And it doesn't have anything to do with whether they go to work in the morning, whether I like it or not. Yeah, so they just denied the restraining order. We were asking for a restraining order to be put in place, meaning that they wouldn't be able to do the ban, but it was a very rare thing. We didn't get the criteria in right, so they denied that, but that's okay. Like I said, it would have only been temporary anyway, and then it would have only lasted 14 days, and it would have went right back into place. So right? But the case is moving forward. Okay, that's the biggest thing, is our case is moving forward. The only thing that happened today was that they granted to remove that lawyer from it, and that's fine. And the case will move forward against the school board, the school superintendent, the assistant superintendent, and the school resource officer. Unfortunately. All right. There were I heard a story, and it was talking about Lot, and how Lot was the one who him and his wife and daughters were they had went to Sodom and Gomorrah, and as they were leaving the city, it was burning down behind them, and they were heading out of the city, and God told them not to look back. Don't look back, just keep going. And his wife, Lot's wife, she didn't listen. And she stopped, and you can imagine, all this fire and brimstone and all this stuff is happening behind you. I'm sure it was loud. And she didn't listen. She stopped, and she turned around, and she looked. And when she did, she was turned to a pillar of salt right then. So Lot and his daughters went on. Could you imagine the trauma that all of them went through after that? I couldn't imagine. But they go off, and his daughter, and he trying to deal with the trauma. He's lost his wife. They just left this awful town and watched it burn, or well, they didn't watch it, but heard it burning down behind them. I'd say he was very traumatized over that. He had wine with him. The Bible tells about it. He had wine. And so he starts drinking this wine, trying to numb the pain and the trauma that he's just went through. And so Lot ends up becoming like a drunk, I guess. Every night he's learning how to cope. He tried to learn how to cope with it using alcohol, wine. And in his drunken stupor, his daughters come up with this plan. We're going to get him drunk, and we're going to go in there and lay with him. And we'll get pregnant. And we'll save our bloodline. Well, they did that. That's incest, right? I mean, they basically R-worded their father while he was in a drunken stupor. And I got thinking about that. And, that is Jesus's direct bloodline. Jesus is a direct descendant of that bloodline, which shows that there is corruption and incorruption within that bloodline. But it made me start thinking about how, we go through really difficult times and really difficult things, and depending on what we grab a hold of as our coping mechanism, how we deal with it. what we do with it. Mary Kelly, the best revenge is living well. That's true. That's true. Lot and his daughters went off and had 2 babies. That's exactly my point, Dave. The moral I got from that story was don't look back. Well, I was thinking about the alcohol, about how he, was traumatized and how he was trying to save his family. All of that they had went through, all of that, the devastation and the shock and the horror of everything that they had just went through. He was trying to save them. He was trying to get them out of there. And the whole time, he's talking to God. If we just aren't careful, what we turn to try and soothe ourselves can hurt us, right? I think there's a whole lot. Yeah, laying with their dad. I think that there's a whole lot there's a whole lot of different ways we can take that. All right, let me get my Bible up here. So we are going to read, let's see. We'll read out of Genesis. We'll go to the Old Testament tonight. And it was Genesis 19, chapter 19, verse 30. All right. We're going all the way back. Chapter 19. It's 21. All right. Let's see. Verse 30. Let's start with 23. The sun was risen upon the earth when Lot entered into Zoax. Then the Lord rained upon Sodom and upon Gomorrah brimstone and fire from the Lord out of heaven. And he overthrew those cities and all the plain and all the inhabitants of the city and that which grew upon the ground. But his wife looked back from behind him, and she became a pillar of salt. And Abraham got up early in the morning to the place where he stood before the Lord, and he looked toward Sodom and Gomorrah, and toward all the land of the plain, and behold, and lo, the smoke of the country went up as the smoke of a furnace. And it came to pass, when God destroyed the cities of the plain, that God remembered Abraham, and sent Lot out of the midst of the overthrow, when he overthrew the cities in the which Lot dwelt. And Lot went up out of Zoac and dwelt in the mountain, and his 2 daughters with him, for he feared to dwell in Zoax. And he dwelt in a cave, he and his 2 daughters. They were hiding. And the firstborn said unto the youngest, Our father is old, And there is not a man in the earth to come in unto us after the manner of all the earth. Come, let us make our father drink wine, and we will lie with him, that we may preserve the seed of our father. And they made their father drink wine that night, and the firstborn went in, and she laid with her father. And he perceived not when she laid down, not when she arose. So he didn't know when she laid down, and he didn't know when she got up. And it came to pass on the morrow, on the next day, that the firstborn said unto the youngest, Behold, I lay yesternight with my father. Let us make him drink wine this night also. And you go in and lay with him tonight, that we may preserve his seed. 35. And they made their father drink wine that night also. And the younger arose and laid with him, and he perceived not when she laid down, nor when she rose. Thus were both the daughters of Lot with child by their father. And the firstborn bore a son, and called his name Moab, the same as the father of the Moabites unto this day. And the younger, she also bore a son, and called his name Benami, the same is the father of the children of Ammon unto this day. And we'll just leave it there. We won't go on because it goes on to talk about Sarah and Abraham. But that told us the story there of Lot and his daughters, and what his, he basically was R-worded, and they got pregnant and had babies. But like I said, they ended up being direct lineage to Jesus. Thank you, Lord, for another day being able to come together in your name. I praise you, Jesus. I lift all of us up to you, Lord. Whatever need each of us have, you know all about it. I pray that you will touch us each according to that need. We praise you today, Lord. We pray that you forgive us for our sins. But, today I feel so thankful. I feel the joy of the Lord today. I feel the peace that passes all understanding within my heart. I'm an open book, Lord. I'm an open book. There ain't no lie that I can tell you that you ain't going to see right through. There's no lie I can tell myself that you're not going to reveal to me and show me. I thank you for being in my life. I thank you for your instruction. I thank you for chastising me when you do. I thank you for all the lessons that you give me. Because all those lessons are not for everybody else. They're for me. I thank you, Lord, for helping me to learn not to give my blessing away. I praise you, Jesus. I praise you, and I thank you for the blessing. I thank you for the favor. I thank you for your mercy and your grace daily. Your mercies renew daily. And I love you, Lord. I pray that you'll go with us tonight. Bring us back tomorrow safely at the appointed time. Keep everybody warm tonight, Lord. And we pray that whatever need each of us have, that you will make a way. We pray that you will take whatever the devil means for evil, that you will turn it around for the good of those who love you and who are called according to your purpose. I pray for your will, Lord. I pray that you help us to receive your will for our lives. Help us to accept it and help us to move forward. Until tomorrow, Lord, we give you all praise, honor, and glory. In Jesus' name, in Jesus' name. Amen. All right, y'all. We will see you all tomorrow night. Peace out, Girl Scout.
Can't hide from hillbilly crime. You can't hide from hillbilly crime. You may not know that there's a crew in town. The head hillbillies are making their rounds. Small town whispers loud and clear. The sheriff shot the judge in his chambers chair.
Sheriff got a secret he won't keep. Judge shot dead in his disbelief. A lot of people have some stories to tell. Dog passed away, get the sound of a shotgun shell.
All the secrets spill on down. Voices loud in this old town. From the courthouse to the ground. Rumors fly and they can't be bound.
Neighbors hide behind their blinds, whisper tales of troubled minds. Skeletons covering the mountainside, a treacherous reality in the pines.
Winter reveals the hidden lies. Moonlight couldn't mask the cries. Shadows caught in sunlit skies. There's no cover, no disguise. All